We do now need to move on to our next fantastic panel. This is going to be chaired by Professor Mary Crock, who is the co-director of SIL and a professor of public law here at the University of Sydney. So Mary specializes in immigration and refugee law and has been listed in the peer-driven publication Best Lawyers in Australia in Immigration Law. She's served on a variety of national, state, and NGO bodies relating to immigration, refugees, disability, and child protection law, and has written extensively on these issues. Of course, she is very well versed in a variety of different fields, as you will see from this particular panel. So Mary, it's over to you.
Thank you so much. In fact, I am going to present this panel with the marvellous Michael Bliss, and I'm deeply grateful that he's able to join us today. Unfortunately, again, we've had to change the program a little because of the events that are happening around the world, and our colleagues at the Office of International Law at the Attorney General's, who usually co-present this material with us, are not able to join us. So, Michael, if you're happy, I might call on you first to speak for about 20 minutes, and then I'm going to come back and tell you a little bit more about what we're doing. May I just begin, however, by acknowledging the marvellous opening session of this conference. I'm speaking to you today from Camaragal land, and SIL will be doing more in the Indigenous space. Unfortunately, the Sydney Peace Prize, which is going to feature the Uluru Statement from the Heart, has now been delayed until November. And so please watch this space, because we will be involved in that process, celebrating it in due course. If I could just begin by acknowledging that the last year, once again dominated by COVID-19, but it had, there were particular events that really touched Sydney Law School very deeply. The first was that we lost the renowned international jurist, James Crawford, former dean of this law school, Justice of the International Court of Justice, much loved friend and mentor to many international lawyers in Australia. So the International Court of Justice, which actually only heard one case last year, it didn't involve Australia, lost a judge. We were very lucky, I think, to have that position on the court filled by Laureate Professor Hilary Charlesworth. And later in this year, when we are able, COVID-19 took over our processes last year, but we will be acknowledging properly the passing of former Dean, International Justice, James Crawford, father to our own dear Emily Crawford, in due course this year. So, Michael, I might now call upon you, and then I'm going to come back and I will be talking to you about what we've done this year. Every year, those of you who follow SIL will know that the Centre does a report, a collection on international cases of interest to Australia that have involved Australia in the international courts and tribunals and in domestic tribunals. So I'm going to ask Michael, who is indeed an alumni of our law school as well. We're very, very proud of him, to talk to us about the work that DFAT has been doing in the international space this year. So Michael, if I could turn to you.
Oh, look, thank you very much, Dr. Crock, Mary. It's wonderful to be on a panel with you. Now, it seems to me that I'm not actually visible, but if that's the case, that is no great loss. I will speak so that I can be
Are you able to press the button that says video?
I've tried a number of times. Let's see if it's working.
I could see you before.
The host has stopped it. So I'm not sure what that means, but in any case, I will speak. Thank you very much. I'd like to begin by acknowledging the traditional owners of the land from which I speak today, the Ngunnawal people, and would like to pay my respects to elders past and present, and also to Aboriginal and Torres Strait Islanders peoples here today. And can I thank in that regard Professor Megan Davis and Tila Reid for that wonderful keynote statement. As mentioned, my name's Michael Bliss. I'm the Assistant Secretary of International Law, and I think I can start my video now. Let's see. Yes, great. So let's continue with hopefully the technology cooperating, if not a little dark. What I'm proposing to do today is dive into the breadth and the depth of international law as perceived by the Department of Foreign Affairs and Trade international law team over the 12 months. But before doing so, I think we have to acknowledge the last couple of days and unfortunately what might be coming. These are surreal days in international law. We were shocked in 2014 with Russia's actions against Crimea. We were on the Security Council at that time, and I was fortunate enough to be the head of the coordinator, the political coordinator of the Australian team. The council met 33 times during that period, and of course, any attempt to get a statement up or a decision of the council was vetoed by Russia. We went through the General Assembly and had 100 countries at that point condemn the actions of Russia. 7 years later, we have seen that those ambitions appear to be much greater, and you've seen the comments of the Prime Minister and the Foreign Minister in relation to this, but over recent hours and days. But clearly this is a breach of the UN Charter and its prohibition on the use of force, and it has been widely so recognised. And many of my colleagues are working directly now on issues arising from this, and you'll see more of that and more statements, no doubt, in the coming days. This has been a difficult time, and we'll go back to 2021 now. I think before going into the subject matter of how we sought to influence and engage ourselves in international law, we need to recognise the challenges of doing so in a time of COVID. The pandemic has changed the way we operate as government lawyers. We remain fully engaged to the maximum extent we can in the discussions that continue to persist around the world, but we haven't been able to travel to many of them. And that has meant that I have had, and others have had, teams who have worked through the night after night, to try and ensure that Australia is represented at the notional negotiating table, sometimes for months on, for weeks on end. And that inevitably changes the way we negotiate, inevitably, and unfortunately, I suspect impedes our ability in some respects to make our maximum contribution. Our part of the world is inevitably worst off, I think. International meetings are usually set for either European or East Coast New York timeframes, and that has meant a huge drain on Australian delegations and probably more reliance on our colleagues in those locations in missions than would be the case. Hopefully that will change. We've seen various attempts at hybrid models, including on Law of the Sea negotiations, which are about to start next week. But I think we're all looking forward to getting back to a point where we can travel, get through the early days of jet lag, and then make a 2-week, often, contribution in the room. And obviously, as you would all understand, that's not merely to be in the room for the negotiations, but to be in the corridors and have the conversations, which really can only take place there in person to get to the outcomes that we are looking for. Whether it's a permanent change to international negotiation approaches is unclear, but certainly it's not slowed down the pace and the dynamism of what a DFAT's international legal work has been over the last 12 months. I wanted to go through under a couple of sort of subheadings, if you like, key elections, and firstly, key negotiations and other actions in which we're engaged, and some key sort of initiatives and processes. And that might not quite sort of cover everything, but I'll do my best to do so in Q&A, if not through these remarks. Obviously, as noted, we were pleased to support Professor Hilary Charlesworth's election to the International Court of Justice to fill the position that the sad passing of James Crawford opened up. I can't tell you how much recognition, respect, and condolences the team received and Australia has received for the work and the life of Professor James Crawford. And I think there was a very strong sense that in a contested election with a very strong Greek candidate, that nevertheless it was important that Australia retain the seat, and with Hilary Charlesworth as our contestant, we had a very strong basis upon which to seek and gain her election. But it was not at all a sure thing, and the efforts of Professor Crawford herself were absolutely outstanding in the way that she spent basically a full month in Jakarta, in New York. Sorry, I had a posting in Jakarta and I get my postings mixed up. In New York, meeting a huge number of delegations and really pressing her credentials, and obviously to a very compelling outcome. So I'll leave that there, but just to the mere fact that we secured the remainder of James Crawford's term for another eminent Australian scholar and jurist was a great outcome, both for the candidate and I think for Australia. We also saw less direct engagement by Australia, but still very important. The prosecutor of the ICC election last year, and that led to the former prosecutor Fatou Bensouda completing her 9-year term, and the Assembly of States Parties electing a new prosecutor, UK national Mr. Karim Khan, QC, who commenced in June last year. We also had in December last year the election of 2 deputy prosecutors of the ICC, Mrs. Nasat Khan of Fiji and Mr. Mame Mandiende Niang of Senegal. We were particularly pleased with Ms. Khan's election. We supported her strongly and made that widely known, and we think candidate from the Pacific region in that position can only be of benefit to the region as a whole. While on the ICC, I should note that we've continued our engagement with the court's important reform efforts, and we will continue engagement into this year and beyond to ensure the court is as strongly placed as possible to deliver on its core mandate, given the range of pressures it faces. Some key negotiations now. Some practical examples adopted in the time of virtual diplomacy, often from home and throughout the night for weeks at a time, as I've mentioned. They can be found across a range of issues, and I like to think that we are working not only in the central questions of international law, but also at the extremities, in space, deep below the ocean surface, and in Antarctica as well. So I'll take you through each of those. But first, cyber. 2021 was a significant year in the international law and cyber advising space. We saw the adoption of the working group on the open-ended working group on cyber, as well as the group of government experts. And for international lawyers, a significant development there was the publishing of the official compendium of voluntary national contributions on the subject of how international law applies to the use of information and communication technologies by states. This includes national statements from members of the group of government experts. And since then, we've seen states who were not part of that process, such as Italy, articulate and publish very detailed and nuanced positions on how international law applies in cyberspace from their perspective. So we're building up this range of views on and publishing voluntary national statements in a way that will be a treasure trove, I think, for international lawyers. We're seeing the development of practice that will strongly influence multilateral agreements and our understandings of each other's positions into the future. On space, and I must say that when I came back into this role, I had not quite prepared myself for how much development had occurred in the 3 years that I had been away. But it saw Australia pursue its interests in outer space through supporting the delegation to the UN Committee on the Peaceful Uses of Outer Space in 4th Committee, COPUOS, as some of you would know it, and supporting the establishment of a UN working group on space resources co-chaired by our colleague, Australia's Stephen Freeland. In late 2001, we saw the establishment of the open-ended working group on responsible behaviours in space. That's for those in the UN lingo, across the UN lingo in First Committee. And its work will be essentially in identifying responsible behaviours and avoiding the risk of miscalculations in outer space. And we will continue in whatever format to actively support the work of the OEWG in 2002 and beyond. On the sea law front, which I briefly mentioned in the intro, there is an immense amount going on. Some of you will be across the negotiations currently underway for a new international treaty under the framework of UNCLOS on the conservation and sustainable use of marine biodiversity beyond national jurisdiction. And that has been hampered by the last 2 years of COVID, and it's not been possible to hold formal multilateral meetings during that period. But there have been many informal discussions at incredibly inconvenient times of the night for us to try and pave the way for proper negotiations when they become possible, as it appears is now becoming the case. The fourth conference, or the fourth session of this conference is due to start in a couple of weeks. It was intended to be the final one. I think many of us involved at the start saw that as a highly ambitious, and you know what that means in diplomatic terms, set of objectives. But nevertheless, I think we've got some prospect for moving forward, if not completing that objective this year. In August last year, Pacific Island Forum leaders, including Prime Minister Morrison in the leaders meeting, adopted the Declaration on Preserving Maritime Zones in the face of climate change related sea level rise. This declaration implements a 2009 Forum leaders' commitment to a collective effort to ensure that once a member's maritime zones are delineated in accordance with UNCLOS, they cannot be challenged or reduced in scope as a result of a subsequent sea level rise. It's groundbreaking. This was the first attempt to tackle this issue. It came from the Pacific Island Forums, where so much sea law leadership has come from in the past, and it continues the region's proud record, I would suggest, of diplomacy and legal thinking on such issues. It's also a case, and perhaps this undermines my earlier arguments, of successful negotiation entirely through remote means to get to a result, at least within the PIF, and maybe that's a reflection on how well we know each other, as much as our mastery of the technology, but it still wasn't an ideal process, but getting to that declaration was a great outcome. On MH17 and state responsibility, this is something that we have been following, of course, since 17 July 2014, when MH17 was downed over Ukraine, and I can add my thoughts on how current developments in Ukraine mesh with this, but we see this as largely a separate process. We have been engaged with a number of countries on a number of tracks, accountability tracks. The substantive phase of the Dutch national prosecution began on the 7th of June 2021, and we're expecting that will conclude towards the end of this year. So that's for personal criminal responsibility for 4 identified individuals, one of them Ukrainian, 3 others Russian in nationality. We've enabled Australian families to participate remotely in those proceedings, to give victim impact statements, and those have been taken by the court, and there has been a very positive response from the families of Australian victims for making that opportunity available. We remain obviously very disappointed by Russia's decision in October 2020 to withdraw its participation in talks on state responsibility for the downing of flight MH17, and should Russia not return to negotiations at some point, then we will be looking at any next steps in consultation with the Netherlands. 2021, but very much right now in 2022 as well, we should move to sanctions and the Maginski scheme, which many of you will have been following. The autonomous sanctions, Maginski style and other thematic sanctions amendment Act 2021 commenced following its passage through Parliament, and that act was followed by reform of the existing autonomous sanctions regulations of 2011, and together they established new thematic sanctions regimes in relation to serious human rights violations and abuses, serious corruption, and significant cyber incidents. And you can see that these tools are being cited and put in place at the moment in response to Russian actions against Ukraine. So what this did was to effectively enable country-specific or thematic sanctions to be employed to impose highly targeted measures designed to influence, deter, and impose costs on perpetrators while minimising the impact on the general population. They give Australia greater dexterity in the applications of sanctions regimes, and they enable us to address concerns relating to human rights, cyber or corruption wherever they arise, and without the need to establish country-specific sanctions regimes as in the past. Getting through a very busy 2021. Obviously, AUKUS was a feature. The Australian government announced in September 2021 an enhanced security and technology partnership with the United Kingdom and the United States, dubbed AUKUS. That announcement marked the beginning of a 18-month consultation period to identify optimal pathways for Australia to acquire conventionally armed nuclear-powered submarines, leveraging decades of expertise from the US and the UK. Following the announcement, DFAT established a new team in its legal division to advise specifically on AUKUS-related legal issues, and that is now certainly up and running and has been for some months. In keeping with the Attorney General's Legal Services Direction of 2017, DFAT, together with the Office of International Law, will continue to provide international law advice to the government on all international law matters pertaining to AUKUS, including on our international nuclear non-proliferation obligations under the Nuclear Non-Proliferation Treaty, and we're committed to implementing the strongest possible non-proliferation standards to maintain the strength of the nuclear non-proliferation regime, and we'll continue to pursue that. The Foreign Arrangements scheme has also received a lot of attention during 2001. It marked its first year of operation late in that year, 2021, and for what is a global first, it provides the Foreign Minister with important visibility of international arrangements and the ability to intervene when they're inconsistent with Australia's foreign policy or adversely affect our international relations, our foreign relations. The scheme safeguards Australia's foreign policy and foreign relations by ensuring cohesive foreign engagement with all three levels of the Australian government. As at 4 February 2022, a couple of weeks ago, over 10,500 arrangements had been notified under the scheme. And they tell a great story about the diverse nature of our international engagement, encompassing economic, trade, cultural, academic and social connections, And as the Minister for Foreign Affairs has said, we expect the vast majority of these arrangements not to be affected at all. Successful implementation of the scheme has involved a lot of virtual engagement, as you'd expect, an incredible amount of engagement with, by our last count, over 700 entities through meetings, correspondence and information sessions, and a whole lot of public information to address some of the concerns that were initially put forward to us. The scheme, basically, that's more than that piece of legislation and what sits over it in the form of monitoring. It's a vital foreign policy arm of the government's network of resilience measures, including the Foreign Influence Transparency Scheme, Foreign Investment Review Framework, counter foreign interference strategy, and the guidelines to counter foreign interference in the Australian university sector. So these measures protect Australia's national interests and guard against undue foreign interference and influence. And we've briefed a range of international partners as to how we've done this and received overwhelmingly positive feedback from stakeholder groups. But a massive workload, and I would vouch from my admittedly fairly interested position, a great work by that team. Treaty actions, I shouldn't leave them till last, but inevitably they sort of get down to the last bit of at least the formal comments. DFAT's facilitated the signature, parliamentary consideration and entry into force of a diverse range of treaties over the past year, many of which involve subjects of high priority to the government. Our team oversaw the tabling of 9 major treaty actions and referral of 6 minor treaty actions for consideration by the Joint Standing Committee on Treaties. We facilitated the signature by Australia of 8 treaties, including the Australia-Japan Reciprocal Access Agreement signed by the Prime Minister on the 6th of January 2022. We've mentioned the AUKUS Information Agreement signed by Australia's Minister for Defence on the 18th of November, and the Regional Comprehensive Economic Partnership Agreement on the 1st of January 2022 as well. A number of others there, of course, but it's a part of the DFAT legal team that works incredibly hard to ensure that we can put the negotiated instruments into effect through the and make sure we deliver our obligations to Parliament through the Joint Standing Committee on Treaties at the same time. So,
Michael, sorry,
yeah.
I'm just wondering if we could maybe stop there so
Yep.
that we give our listeners time, hopefully, to ask some questions later.
Yep.
We're both doing this remotely, so I'm going
Yep.
to need people to ask the questions in chat or to raise their hand in the studio, and Stacey can take questions as well. Is that okay, Michael?
That's okay, and in fact I had only a couple of paras to go, so happy to leave it there, and sorry
Okay.
to
No,
have had
no,
so
not
much
at all.
to say.
Look, I think that was a bit of an innovation for this conference, and I think it's something that we will want to repeat, because I think to have a representative from DFAT explaining what the government has been doing in the international space is incredibly valuable. So I appreciate that enormously, Michael. Thank you so much. We will have some question time, hopefully, afterwards as well. So what I wanted to do now is just to very briefly
Mary, if I can just intervene, this is Stacey.
Yes.
If you can you can have time until 50 minutes past the hour, and I don't know what time you want to stop for questions, but since you started late, we'll give you a couple 10 extra minutes.
Okay, Stacey, I'm conscious of running the data time though as well, and so I know that we've got some morning tea time, which is good, but I don't want to intervene too much in that.
That will be fine. So if you go to 10:50, then we will have a 10-minute break until 11 o'clock and start again. So we don't want to cut you guys short because it's important information.
Yeah, okay. Look, as I said, Michael, I think that this was incredibly valuable, really superb. So thank you so much. What I'm going to do now is just to tell you briefly what the SIL people have been doing, and I want to acknowledge here the interns who have worked with me and who in fact have helped me to prepare the material that I'm going to be presenting to you today. I'm going to start by sharing my slides here. I'm going to begin by talking about what I think the people from the Office of International Law would have been helping us with first. The material is collected and will be published in the Australian Yearbook of International Law this year. And I think the take-home message, and Michael, you can probably confirm this for me, is that in the international space, in the courts and tribunals, a lot less happened than in the domestic courts. Our domestic courts seem to have picked up much more quickly than the international fora. The cases in the international fora have been summarised for me and with me by Mia Bridle, Ben Djokovic, Emily Halloran, Catherine McCormick, Eden McCaffrey, Madeline Pfefferkorn, and Marie Shankala and Alicia Vakalopoulos. And I wanted to name them and acknowledge them because they've just done a tremendous job. I mentioned the sad passing of Justice James Crawford, which we will acknowledge later in the year. I just thought I would go through this almost in alphabetical order. We found one case by the Court of Arbitration for Sport. I know that our young viewers and listeners are always interested in that. So we have summarised the case involving Shayna Jack, the swimmer, who was first suspended for 4 years, and the World Anti-Doping Agency and Sport Integrity Australia essentially part of an appeal process that was ultimately successful. Shayna Jack has now served out 2 years of suspension, and they have reduced her suspension to 2 years, saying that, or a majority of the panel accepted that the breach was unintentional, that there was no intent or recklessness in the drugs that she apparently consumed improperly. Okay, so what I'd like to do now is really take you back into the international fora, and we'll go to the Human Rights Council first, and then we'll go to the Human Rights Committee. They both actually meet in the marvellous Salle Val, room 20 in Geneva, which has that incredible ceiling by Gaudi. Most of you will be aware that there are two processes really where Australia has to stand up in front and to meet international concerns about its human rights behaviour. One of them happens every 4 years, and that is known as the Universal Periodic Review. It is a much softer review than the reviews that are undertaken when each of the treaty bodies meets and scrutinises Australia's behaviour. So 2021 saw us front up to the Human Rights Council for the Universal Periodic Review. And I think what was interesting for me in that process was that Australia was commended, as it should have been, I think, for its response to COVID-19. far fewer people died here. As our speakers this morning have acknowledged, there are more Australians alive today because of what has happened at our responses than would have been the case otherwise. We are traditionally criticised very heavily for our treatment of Indigenous Australians and of migrants and refugees, particularly those who are being deported for committing criminal offences, and for those who are caught in indefinite detention or sent for offshore processing. No surprises in that. What is interesting, though, is that the UPR picked up this time some of the domestic royal commissions that we've seen in recent years on the abuse of older people. The work of our Australian of the Year in the domestic violence, family violence space, these really caught the attention of the reviewers, and so too did the work of the Royal Commission into the abuse of persons with disabilities. So we were castigated in those spaces as well, which is interesting. Okay, so I'm going to whip through this very quickly because I am keen for our listeners to, Michael, if you could perhaps just mute your...
Oh, sorry.
That's all right, then we get a few background noise. I'm just going to take you through the cases that have been brought against Australia in various human rights committee forums. So you'll be aware that there are 9 human rights conventions altogether, or is it 10 now? And for most of those, they have associated with them a committee peopled by individuals elected to those committees. So Human Rights Committee, at the moment, we don't have an Australian member, but last year, 2001, we had a very interesting case brought, in fact, by Kim Rubenstein, a professor from Sydney, who's now running for Senate down there, from Canberra rather. And she brought complaints to the Human Rights Committee on behalf of 3 Australian citizens who were living overseas, and because of the federal government's imposition of caps on international arrivals, were unable to return to Australia. And in April 2021, the committee requested urgent interim measures, orders from Australia to basically allow these people to come home. And one of the questions I might have from Michael, if you could take it on notice, Michael, is Australia responded straight away by saying, please lift your request. I assume that all 3 of them now happily back home, but I'd love to know what the status of this application is at the moment. The reason it's interesting is that you'll see when you have a look at the list of domestic cases that there was something like 5 cases that we chose to distill and discuss that all relate to aspects of border closures, COVID-19 measures. Universally, they have failed. So domestically, every attempt to invoke human rights law and to really foreground the terrible human rights impact that the COVID-19 measures have. There's always 2 sides to the story. A lot of lives have been saved, there's no doubt about that. But what I think is interesting in the domestic space is that the courts will not engage, have not engaged with the international legal issues around the impact of these COVID-19 measures. Understandably, they really are literally between a rock and a hard place, but the contrast between what the Human Rights Committee has done relative to what the courts have said is very interesting. Okay, second international committee matter that was decided, opinion given last year. Of course, these opinions and interim measures are not remotely binding in any international legal sense. The statement or the opinion issued by the Committee on the Rights of Persons with Disabilities does have more status under international law and very interesting. Please forgive my typos on this slide. This was interesting. Sherlock against Australia, views adopted by the committee under Article 5 of the optional protocol of the CRPD. Australia still has a member. In fact, I do believe, Michael, that our member is currently chair of the committee. Am I correct? I think so. Yes. Now he's muted. Anyway, Sherlock's case is interesting because it raised questions about the legality, lawfulness under the CRPD of Australia's stringent health rules. And we have been criticised both in the UPR by the CRPD when it reviewed Australia, and now in an individual complaint about the operation of Australia's immigration health rules, in the sense that this was an individual who had a disability and an illness, multiple sclerosis, who would otherwise have been very welcome in Australia, highly gifted and able person. And the committee said, look, this is literally discrimination. You are not actually looking at the real cost that this person will represent for Australia, because you're not taking into account the benefits that she will bring. So there we are, a very interesting case that we have extracted that you can read about. The last matter that we have added to our summaries this year relate to the report of the group of governmental experts on advancing responsible state behaviour in cyberspace. For those of you who are interested, the Jessup compromise for this year involves cyberspace activities, and for that reason was of great interest to Eden McSheffrey, who was one of our intrepid mooters for this year. So he drew this to our attention, and so, Michael, we have included it, which is terrific. The last matter that I will mention in the international domain relates to extradition of Julian Assange. We've been tracking this case and the ongoing saga surrounding, sort of related in some ways to the cyberspace issue, isn't it? But Julian Assange, last year we were presenting to you a win in the London courts. This year the news for him is not nearly as good. The saga continues. In our domestic summaries, we actually include two extradition cases, which are quite interesting. Rivas against the Republic of Chile and Matson against the Attorney General, which both raise very interesting issues of extradition. The Rivas case is, and Michael, please feel free to comment if you want to on any of these in due course, but the Rivas is the case involving the nanny in Australia who was the secretary to the Chilean president at the time of the disappearances. And that matter now may be headed for the High Court, but we have been so far successful in at least moving towards getting her extradited for crimes against humanity, which is very interesting. Okay, so domestic cases And I have prepared a list, which I'm not going to inflict on you in this visual context, but the cases range from a very interesting case on consular territory dispute, when are domestic premises covered by consular immunity. Very interesting case from Victoria involving the Consul General of Turkey, who got into a building dispute with some contractors, and the question really was, did that dispute have to go to the Victorian administrative tribunal, or was it a matter of consular gravity such that it had to go to court rather than to a tribunal? Long story short, spoiler alert, the courts accepted, looking at the Vienna Convention on the Law of Consular Relations, that a domestic premise, particularly when it is a very fancy Turkish premises built in Turkish style, or it's used to really host and promote Turkish culture, that indeed, I find it very hard to disagree with this ruling, to be honest, because I am a bit of a fan of Turkish everything. So to the courts they go, and sorry, the tribunal out the door. They were not able to have any jurisdiction there. We are going today to be looking at a number of the areas that are listed on our little list, and the interns who worked in this area, I read them out for the international cases. I'm going to acknowledge them for the domestic cases as well. Mia Bridle, Ben Jakovich, Emily Halloran, Catherine McCormack, Eden McCaffrey, McSheffrey, Madeline Pfefferkorn, Marie Shankala, and Alicia Valkolopoulos. I'm going to acknowledge you guys in due course, because some of you have just gone over and beyond the call of duty, and thank you also to Rosemary Gray, who always steps up for these things too. Some of the cases that I mention here almost overlap with private international law, and I want to acknowledge here that my co-director is actually helping us to do a third article on private international law, and in due course the interns that she has been working with will be acknowledged as well. So to go back to my list, consular disputes, the other big issue, and Michael has acknowledged this already, is environmental law. A lot happening in the treaty space, and really interesting matters in the domestic fora as well, with cases like bushfire survivors for climate action against the Environmental Protection Authority, Sharma by her litigation representative against the Minister for the Environment, Sander against PTTEP. International law has featured front and centre in these cases, with attempts by private citizens to force governments to comply with their international legal obligations in both the crafting of policies and in the making of particular decisions. Really, really interesting space. We have a whole section on environmental law, and so I won't dwell on there anymore. We then go down the list. Extradition, I've mentioned. We always have some Hague Convention cases. We just put one in this year. International arbitration. You know, we could find no WTO cases to report on. I think there was one report that came in at the very end of the year, but it was just a bit of a bridge too far from me. I was managing this from America, actually, as I awaited the birth of my first grandchild. Oh, yes. So we have included the international arbitration case, the Kingdom of Spain against Infrastructure Services Luxembourg. Again, I think we'll see a lot more in this area as we move forward. We've included a a case on offshore mining enterprise, the Bougainville Copper against RTG Mining. I think we've included 4 public health orders, and the case, unfortunately, that our expert from oil was going to talk about, ADDI against the Commission for Taxation, very interesting case on the classification of earnings by foreign temporary migrants. Very interesting case, significant case. I just want to finish very quickly by mentioning that there are, as ever, a whole pile of migration cases. And I think I just want to make this point. In the cases I've spoken about thus far, the courts and the litigants have been very happy to talk about and to engage with international law. You get into the migration space, and the litigants very happy to engage with international law, but the courts absolutely, in part because of changes to the Migration Act in 2014 that stripped out all mention of international law, they have become resolutely domestic law in their focus. But at the same time, we have not withdrawn from any of the key conventions, including the Refugee Convention, the Human Rights Convention. So we have cases on complementary protection where the courts have engaged with what are effectively key elements of international human rights law. The cases on criminal deportation, mandatory detention, extended indefinite detention, unfortunately, we had a very significant case, Commonwealth of Australia against AJL 20, which promised to be an opportunity for the High Court to revisit the decision from 2004 in Al-Kateb and Godwin. The decision went the same way as Al-Kateb and Godwin, 4-3, with the majority saying, yeah, they just would not engage with the fact that this person who could not be removed from Australia, who was a refugee, they have acknowledged effectively that the obligation not to remove is there because they are refugees, often people with disabilities as well. But if they can't be removed, if Australia chooses to leave them in detention, the court basically won't engage with that. Series of other cases that I'll leave you to read over time. I chose to include the case of Minister for Immigration against EFX 17 because it's a very interesting case involving a person with disability, no language proficiency, psychosocial illness, clearly couldn't understand anything, and yet the court, again, doesn't engage with any of the straight up human rights issues, chose instead to, yes, give a result to the candidate, to the applicant, but on very narrow textual grounds, saying, oh yes, well, he wasn't given the exact time that he had to respond to this notice. Series of cases, they all involve individuals who really do engage Australia's international obligations. So what we do is we see the courts really turning, really becoming quite torturous in acknowledging that they are individuals who need help, but they won't talk about international law. So I'm going to stop there. That gives us, I would like people to ask Michael some questions. They can talk to me anytime. Okay. Stacey, did you have anybody in the room who wants to?
Yes, we do have someone with questions. Hang on.
Let's do that. That'd be great.
Tim Stevens from the University of Sydney Law School. It's great to see you, Mary, and Michael up there on the big screen. My question's to you, Michael. You referenced in your remarks the challenges of moving diplomacy online during the COVID pandemic, and I just wonder if you wouldn't mind fleshing out the kind of practical challenges that you've faced and whether or not you think that the move online has had substantive impacts in terms of the outcomes of certain negotiations.
Thanks, Tim, and good to hear you at least. And it's a great question. Very happy to extrapolate. We've always been geographically disadvantaged, if you like, which has involved, I think, primarily up until a few years ago, the extent of time that we have to spend getting to and from the centres of multilateral negotiation.
I'm going to lie down.
Is it working? And as a result, we turn up jet lagged. We find it hard to get through the first afternoon session on a Monday, and we sort of get more engaged as the week goes on, and plan our schedules accordingly. But we note that when people come down from Western Europe, for example, or the US to Tasmania for the CAMLA meetings every year, they complain about how far it is, how long it takes. Is this really essential to engage? And we say yes, and we do it about 20 times more frequently going to your capitals than you do to Hobart in that case. And I think there's the other dimension which I mentioned, but I'm happy to go into. A very senior and experienced Canadian diplomat said to me quite early in my career, working on something ICC related, said, remember, keep everything in the room as flat and as unexciting as possible, sort it out in the margins. And that's what we do. And that's how it is expected to work. And nothing sort of technologically pushing a button and having us a little chat on the side of a meeting is going to have quite the same effect. It's an old school view, but I think it persists. And I couldn't imagine, for example, some of the climate change discussions that you know very well being as effective, if that's not too high a description of them, of their outcomes, if they were constraints rather to this view. I also am conscious increasingly in running a team of very engaged, committed officers, that they are not getting the training and the experience that would ordinarily be the case in a scenario where they could be part of a delegation that is going and learning and being part of the delegation, often having opportunities that they would not otherwise. And I think that's fundamentally part of what we do as diplomats and lawyers. And it's I'm just hoping that there will be a chance when we can get back to it.
We are going to,
Michael.
Stacey, and we are going to need to call it a halt here. Please, would everybody in the room and online please give our great thanks to Mary and Michael for doing a fantastic job. And my last comment to Michael before we go on to break is that my sister occasionally negotiates with the American team and has come down to Australia for TPP, adores it, and she keeps wishing that she would get sent down here more often. And I keep saying, you can always visit me, but you know, that's not as important as negotiating for the US. So thank you both. For the people online, we will be taking a break here in the room, as well as you guys can do what you like in terms of food, but we will be back at hopefully 11 on the dot, or maybe 11:01. So see you in a few.